Swayam Prabha. Digital India. Educated India.
Dear students, and today we are going to discuss about the enforcement of the antitrust law vis-a-vis IP law in the United States. In the last classes, we were discussing about the entire provisions and implementation of the antitrust law vis-a-vis intellectual property law in the United States. And today specifically we are going to discuss the various agencies involved in the implementation of the intellectual property law as well as the competition law, that is the Department of Justice, FTC, that is the Federal Trade Commission, and their various programs to implement the antitrust law, and different, of course, the different areas of enforcement also we will be discussing. So, antitrust law, it is very clearly saying the Department of Justice very clearly saying what is the objective of the antitrust law. And antitrust law is specifically to protect the economic freedom of the market as well as promoting competition in the market, and there must be free and fair trade or free and fair competition in the marketplace. This is the objective of the antitrust law. At the same time, these free markets which enable the entire market to the consumer welfare, that is the ultimate objective of this competition in the market, and this will enable to lower the prices, better the quality, better the consumer choice, and also which leads to the welfare of the consumers ultimately. And moreover, it provides business opportunities for the new entrants and to compete in quality, in price, and in an open market, and there must be a level playing field in the market for the new entrants. So, if there is no competition in the market, if there is only monopolies or oligopolies in the market is going to be distorted. These anti-competitive restraints which enable the new entrants or there must be promoting competition in the market. If you look into the provisions of the Sherman Act, which we already covered, clearly the section 1 of the Sherman Act says prohibits which contracts, combinations, and conspiracies in restraint of trade, and also it restrains and prohibits unreasonable restraints of trade. So, typically which is impacted economic, which is differently which attracts and affects the economy of the United States. And thirdly, we can see the agreements. Certain category of agreements, business agreements, are held per se illegal without any further analysis, or there is a presumption in favor of per se rule, per se illegal rule. And per se illegal when the competitor is engaged in price fixing, division of markets including vertical as well as horizontal markets, bid rigging, group exclusions, etc. So, section 1 very clearly prohibits these combinations and conspiracies to restrain trade. If you look into the penalties which is imposed, there are criminal penalties as well as civil penalties. And this one of the country where imposed criminal penalties were the United States, and in violation of these provisions Sherman Act, which will attract 10 years in prison for individuals, and this is very harsh punishment which is imposed in the Sherman Act. If you look into the India, you can find that there is no jail term, there is no criminal penalties which is provided in the Competition Act, and fine is also very huge amount. So, the criminal fines are up to 100 million for corporations or twice of the loss or gain from the violation, which is greater in quantity. So, the fines are also is huge amounts will be imposed as fines. And in the case of individuals, even criminal fines up to 1 million or twice the loss of gain of the violation, whichever is greater, is also will be imposed as a criminal penalties. If you look into the civil penalties, we can see that there will be treble damages available to the successful plaintiff, which includes even the attorney fees and cost of litigation. And there is joint and several liability will be imposed on the defendants in case of civil penalties. And mostly the enforcement in the enforcement of antitrust law in the United States is by two agencies. The first one is the Department of Justice, which is the law enforcement arm of the executive branch, and the second is the Federal Trade Commission, and which is constituted under the Federal Trade Commission Act, which is an independent regulatory authority created by the Congress. So, and third category, which we can see that there are lot of individual attorneys, all over attorney generals all over the states have also a role in enforcing the antitrust law. And the fourth category is the private persons and non-governmental organizations, civil litigants and others, those who file cases against the big companies, those who engage in antitrust violations. If you look into both the agencies FTC and Department of Justice, they work each other. In some areas their works are overlap each other, but the two agencies complement each other. They will always try to see that there is no overlapping of initiations by both the agencies. So, both the agencies are expertise in certain areas or industries and markets, and so they cooperate each other and transfer informations, share informations each other. So, there is no overlapping of enforcement. If you look into the FTC, the FTC is the independent regulatory authority, and which spend their resources in certain segments of the economy, or they specialize in certain areas of the economy, which is the consumer have a lot of spending in the American market. For example, the healthcare sector, like pharmaceuticals, professional services, food, energy, and then high tech industries like the computer giants, internet services. So, these agencies specialize in these areas, and they consult with the Department of Justice before initiating any initiation in order to avoid duplication of their investigations. And on the other hand, Department of Justice, there is a division on antitrust law, and those who bring criminal charges against individuals and companies who harm American market or who harm the American consumers. So, like fixing prices or bid rigging, allocating markets, and all the categories, or tying or bundling, other categories of offences, which we will discuss it later. So, Department of Justice is basically headed by an assistant attorney general for antitrust. So, they focuses or they initiate civil and criminal provisions under section 1 of the Sherman Act, section 2 and section 7 of the Clayton Act. They enforces these provisions virulently in the American market, or the companies, corporate or individuals, those who are violating the antitrust provisions, they initiate prosecution in the court. So, the Department of Justice exclusively responsible for the criminal enforcement of federal antitrust laws. So, in some of the cases like the United States versus US Gypsum, the court held that the government must prove criminal intent to obtain a criminal antitrust conviction. So, a greater quality or greater quantity of evidence or greater evidence is required to initiate the criminal investigations. So, that is the court said that the criminal intent must be proved, then only they can initiate the criminal action against the violation of the Sherman Act. So, they working with grand juries, they working in the jury system. If you look into the criminal enforcement in the last almost 10 years, the Department of Justice releases this data every year, and we can see that the corporations are less prosecuted than individuals, and in almost every year for the last 10 years, every year the individuals are very high in number prosecuted by the cases or charges are leveled against individuals than the corporations. It means that the corporations are either they are complying with the antitrust law, or the complaints against the American companies are very less. For example, in the year 2018, last year, there is only 5 charges. The 5 corporations are only charged with antitrust violations. So, that is the case in most of the years, the number is approximately 20. So, it means that corporations are more complying with the antitrust provisions than the individuals. So, it is very clear that more individuals are involved in the violation of the antitrust provisions in the United States. So, the grand jury system is prevailing in the case of this act as well, the Sherman Act as well. So, the grand jury is convened under the authority of the court, and it is run by the prosecutor, and then finally, they come to the conclusions. So, here in order to avoid, so there can be settlements with the authorities, Department of Justice. So, the Department of Justice runs 2 programs for settling disputes with corporations and settling dispute with individuals. And with corporations, it is known as the corporate leniency program, and with individuals, it is individual leniency program. And these programs are to settle the disputes with a lenient mind. So, this program is applicable is most importantly those who are cooperating with the investigation, or those who are voluntarily comes and discloses the antitrust violations to the Department of Justice. And it is basically to investigate, it is a tool, it is used as a tool for detecting cartel activity, like in the case of in the case other cases, the people those who are giving information will be considered very leniently. So, here the corporations and individuals, those who report their activity, report their anti-competitive activity to the Department of Justice and cooperate fully in the division's investigation of cartels, can avoid criminal conviction, fines, prison sentences if they meet with the requirements or preconditions of the program. And again, if you look into this program, you can see certain conditions. So, here the leniency programs is availed by the corporations as well as individuals. So, this must be their activity must be reported to the Department of Justice at a early stage, and that information must not be reported by anybody else. So, they must be the first person to report that particular activity to the Department of Justice. So, in this case a leniency will be shown to the informer, and along with report on others, those who are doing this particular activity. And so, a leniency will be shown to those people, those who disclose or give information to the authorities. And also this policy is also known as corporate amnesty or corporate immunity policy. This is in line with the famous the criminal jurisprudential system. Those who give information, those who give information on the commitment of a crime, and they will be leniently considered. So, again here corporation reporting activity must be investigation before the investigation began. So, the information those who are giving to the DOJ must be before starting the investigation, not after starting the investigation. That is one of the conditions. So, again, so the corporation upon the discovery of such illegal activity being reported, they took prompt and effective action to terminate the part of activity from their activity. So, they must be terminated their promptly terminated their that particular activity, and this confession or wrongdoing is truly corporate act opposed to the opposed to the individual confessions by the executives and other officials of the company. So, these are some of the conditions to be preconditions to come under the corporate leniency program. Then once it comes to the individual leniency program, so the leniency program has been extended to individuals as well. So, this applies to all individuals, those who approach the Department of Justice on their own behalf. So, voluntarily disclose information to the Department of Justice. The conditions are, it must not be as a part of the corporate offer of confession and seeking leniency in reporting antitrust activity. So, this must not be previously been made aware to the Department of Justice by anybody else. So, he should be the first person to report this particular matter to the Department of Justice. Then other the conditions are, the leniency will be granted to an individual reporting illegal antitrust activity before investigation has begun. So, they must meet minimum 3 conditions, and the first condition is that the individual comes forward to report the illegal activity, the division has not received the information about the illegal activity. So, they should not already got that particular information from any other source, that is the first condition. So, the second condition is the individual reports or wrongdoings and complete candor and completeness, and provides full, continuing and complete cooperation to the Department of Justice throughout the investigation. That is the second condition to avail this individual leniency program. Thirdly, the individual did not coerce or another party to participate in the illegal activity, and clearly was not the leader or originator of that particular activity. That is the third condition to avail the individual leniency program. Then civil enforcement, if it comes to the civil enforcement, and the Department of Justice has the power to attack antitrust violation through civil enforcement as well. So, this is usually initiated this in the case of less serious, less clearly illegal or harder to prove activity than the hardcore activities. So, in the case of hardcore activities, the criminal prosecutions will be initiated, and the civil actions will be initiated against less the less hard, we can say that less hard activities. And also other than this, the Department of Justice has enforced merger enforcement as well. The companies may merge, the companies may acquire another companies. Mergers and acquisitions along with joint ventures are not illegal per se, but the Department of Justice, the antitrust division have the authority to look into each and every activity, each and every merger. When merging of companies are not illegal, but they can look into the activity, whether it is for avoiding or whether it is for fixing the prices, whether it is for dividing the market, or whether it any other illegal antitrust activity, whether it has been taken place or not. Because these responsibility investigations are shared with the Federal Trade Commission as well by the Department of Justice. So, if you look into the merger enforcement, we can see that the merger is the provisions, the major provisions which is applicable to the mergers are section 7 of the Clayton Act and section 1 of the Sherman Act and section 5 of the FTC Act. So, here section 7 of the Clayton Act prescribes a major effect of which may be substantially to lessen competition. So, the per se rule is not applicable here, the rule of reason is applicable here. So, if the merger is only for, it is going to be substantially lessen the competition in the market, then only the competition authorities or the antitrust authorities, the Department of Justice and FTC is going to look into this particular activity under section 7 of the Clayton Act. And if you look into the section 1, specifically prohibits any activity agreement that constitutes an unreasonable restraint of trade, that is section 1. And section 5, the Federal Trade Commission enforces or prescribes unfair methods of competition. So, there are 3 acts, one is the Sherman Act, 2 the Clayton Act, and 3 the FTC Act. So, all these provisions of these acts, under these provisions, these the enforcement agency can look into the mergers of companies. And another method is the companies can go to the authorities, Department of Justice or FTC, and take their views on the activities. So, basically these business review letters are nothing but advices from FTC, so law enforcement agencies on competition. So, here the persons concerned about legality. So, the companies or individuals themselves want to make it sure that they are not entering into any kind of illegal anti-competitive activities. So, they can approach the Department of Justice or the FTC. These are the proposed business conduct, particular business which they are going to carry out, and then current enforcement intentions with respect to that of the conduct of that particular business. So, the Department of Justice and the FTC can look into that particular business, review the entire process and issue a letter. A business review letter can be issued by these particular agencies, which will make it sure before starting the business itself, the businessman will be very clear that they are not entering into any illegal activities under the Sherman Act or the Clayton Act or the FTC Act. These business review letters, basically it is important, it gives an important activity for the businessman or giving an opportunity to the businessman to get guidance from the department with respect to the scope, interpretation and application of the antitrust laws to a particular proposed conduct. So, it gives in advance the advice from the Department of Justice or FTC with regard to a particular business activity. So, the companies or the individuals can very well make it sure that the activity which they are going to or the business which they are going to start or the business method is not anti-competitive in nature. So, the authorities issue business review letters as well, and this is in the form of advice, advance advice to conduct a particular business, which will be beneficial to the industry as well as beneficial to the enforcement agencies. And again you can see the process, which is very simple, and this is in response to a written request outlining the parties proposed business, proposed conduct, and then the antitrust division will issue a business review letter. So, the party seeking such letter must provide a detailed description of the planned activity along with the concerned documents. And in response to the information which is disclosed to the department, the division may not state its present enforcement intention, take such other position or action it considers appropriate. So, the Department of Justice, they advise this particular activity whether it is going to violate any of the provisions of the competition law. Then comes, these are the activities of the Department of Justice, and now we will look into the activities of the Federal Trade Commission. And Federal Trade Commission is an independent regulatory body which is constituted under the Federal Trade Commission Act. So, it is basically led by the 5 commissioners appointed by the president for a 7-year term. So, they have much higher responsibility. So, the FTC has 3 bureaus, one is the Competition Bureau, Consumer Protection Bureau and Economics Bureau. So, they have a larger role to see whether the competition authorities are harming consumer interest and economy in general, whether the economy is harmed or the market is harmed. So, the Federal Trade Commission, their mission is prescribed in their website very clearly to prevent business practices that are anti-competitive, deceptive or unfair to consumers. So, and the second objective they put it is consumer protection. They clearly said that the Federal Trade Commission Act, under the Federal Trade FTC Act, unfair or deceptive acts or practices or affecting commerce are declared unlawful. And thirdly, they look into the competition. The FTC Act also prohibits unfair methods of competition. So, and any kind of conduct which violates the Sherman Act or Clayton Act as well. So, FTC have a larger role. They look into all the legislations and they are involved in the enforcement of all the antitrust legislations, but they will always try to see that it is not duplicating with the Department of Justice. They work in hand and they consult each other in order to avoid duplication of actions. Basically, FTC administer the FTC Act and principally section 5 to enforce the Clayton Act and the Robinson Patman Act. And also we can see that they enforce Sherman Act as well as the Clayton Act and indirectly under the section 5. So, there is a broad mandate which is given to the FTC Act under section 5. So, they can interfere, they can enforce any of the provisions of whether it is FTC Act and primarily on FTC Act, then Sherman Act, then Clayton Act. So, they can enter into, they can look under the various provisions, they have the jurisdiction to look into the specific conduct of the industry. And at the same time, the FTC shares their responsibility to the Department of Justice for merger enforcement, and then again with for promulgating and enforcing pre-merger notifications, which is implemented under the Hart-Scott-Rodino Antitrust Improvements Act of 1976. And also it is an independent agency. They have the power to pass cease and desist orders in the case of violations of the FTC Act under section 5. So, they have wider powers under the FTC Act than in the other legislations. And if you look into some of the enforcements which they are put it in their website, we can see various categories of cases dealt by the FTC. For example, in the case of settlement of in-app purchases, there is a 32.5 million settlement with regard to Apple and all major companies which you can find. In the case of Honeywell, merger of barcode scanner companies. In the case of competition, Honeywell, Nielsen and Vice Media, Justa Digital, then Tennet. So, all these cases, different categories of disputes cases are dealt by STC. So, they will look into competitions, different kind of activities involving the latest technologies, the technology companies. Also, they will look into the different kind of cases and they take action against companies those who violate provisions. When it comes to the enforcement of the intellectual property involved competition law cases, the FTC is very active. And we know that these cases are very technical in nature, very complicated in nature, but the FTC deal these kind of cases in a series of areas like cross licensing, patent pools, refusal to deal, tying and bundling, then market divisions and all this we dealt in detail in the last classes. What are the activities, and the FTC look into these activities and enforce the particular provisions. So, here specifically the FTC look into whether these companies, the patent owners are going beyond the rights conferred under patents or copyrights or trademarks, and they look into the antitrust angle of their dealings, especially in the case of licenses or cross licenses or agreements, franchisee agreements, etc., etc. So, the FTC have a dual role. They have to look in from the intellectual property protection, as well as they have to look into the competition law perspective as well. So, they usually look into the price fixing and also the coordinated output restrictions, foreclosure of innovations, and prohibited other antitrust activities, which they very closely look into and which will be always controversial in nature. And also we can find intellectual property is also coming in merger control as well. So, innovation is the mantra of now the mantra of success of any particular companies. So, innovation can be purchased, from another company, innovation can be acquired through mergers of another company. So, this will increase the competitiveness of the company or increase the firm's ability to compete with its competitors in the market, and also put pressure on the competitors to innovate themselves, so that there will be a fair competition in the market. But these mergers must be approved by the antitrust authorities. So, it must get the signature of the antitrust authorities, because the merger rules very clearly says that none of the merger should not be for violating any of the provisions of the Sherman Act or Clayton Act or FTC Act. So, no mergers can violate these particular provisions. If it is found, then definitely these law enforcement agencies will come and they enforce these particular provisions. And so, we can see the mergers. In the case of mergers, there can be structural as well as or behavioral aspects, remedies which we can find. So, the structural remedies are basically related to the selling of the activity, a line of business company, in order to immediately restore competition in the market, and the behavioral remedies are basically to modify or constrain the market conduct of the merging firms. So, the mergers have always have an angle of antitrust. So, it should get the signatures of the antitrust authorities in order to merge companies. And there is a lot of controversy, especially in the case of technology licensing agreements. So, the licensing practices like technology grant back or tie-ins, territorial market limitations, and field of use restrictions, and all these restrictive will be addressed in the case of technology licensing. So, the agencies, the FTCs, to look into these kind of activities very closely, and also the treaties, this kind of activities it sometimes cannot be declared as per se illegal, and the FTC has to look into these activities specifically under the rule of reason standard, and to see whether it is for the welfare of the market, whether this is going to be welfare for the market or not. So, the rule of reason approach of the STC is the Federal Trade Commission, and they look into these agreements through the applying the rule of reason, and this can be a potential or competitive and have existed without the agreement, it may be considered restrictive in nature. So, it means that the rule of reason is the basic the criteria to look into these particular agreements by FTC. So, and the intellectual property, they always have giving rights, intellectual property rights for a limited period of time, and the enforcement agencies always look into whether these owners of the intellectual property are exceeding their rights conferred under the patents or trademarks or copyrights. This is the main duty of the enforcement agencies, and this is very complex in nature as well. And in the case of patent rights, as I told you, the patent rights always give monopoly for a limited period of time, and the patent holders license, cross license, and even assign their rights to other companies that may be the competitive companies. But the agencies, the law enforcement agencies always look into the purpose of the mergers or purpose of the transactions, purpose of the cross licensing, or whether it is for the stopping or restraining competition in the market. This is the duty of the agencies in the case of such the cross licensing agreements, looking into the cross licensing agreements. And here even the smallest IP, intellectual property, smallest patent also can have yield big quantities of royalties, because the competitive company may want that particular patent to compete in the market along with their rival companies. So, in the case of portfolio cross licenses and patent pools can solve this particular problem in that case, and these pooling, cross licensing and pooling of patents are not per se illegal. Again, the rule of reason will be again applicable in that particular case. So, usually this will reduce the transaction cost, this will be mitigating hold up problems, and this will be good for the market. So, the FTC will look into these proactive conditions to determine whether it is anti-competitive in nature or not. And licensing, which we already discussed in the case of licensing, and licensing activities are not at all prohibited. So, licensing activities which lead to any kind of activity which leads to anti-competitive in nature, then only the FTC will consider it as violation of the antitrust provisions. See here, and moreover, if you look into these individual activities the FTC looked into, for example, in the case of refusal to license. So, competition law generally imposes on firms a duty to deal. Refusal to license is violation per se considered to be violation of the Competition Act, but when a firm refuses to deal with a customer, most of the circumstances we can see that there is intervention by the competition authority, intervention by the Federal Trade Commission or Department of Justice, and in all times it is not justified as well. So, here if the only question which the enforcement agencies can look into is such refusal of such an opportunity is fair, or whether it is rational on the part of the firm. On the other hand, refusal to deal with a competitor may be an abuse. So, usually refusal to deal will be considered as anti-competitive in nature, but when we apply the rule of reason, it may be pro-competitive as well. So, it is the duty of FTC to look into, the agencies to look into the pro-competitive effects on the market. And these another area is the tie-in arrangements and bundling, which we discussed earlier elaborately, and tie-in arrangements are per se considered to be illegal, per se considered to be illegal under the antitrust provisions. Here you are compelling a customer to purchase something which he does not want to purchase along with an item which may be patented or which may have a intellectual property protected product. So, bundling always is considered as two or more products bundled together is considered as anti-competitive in nature. Otherwise, it is the duty of the defendant to prove that the bundling which is that bundling of such products is have an effect of pro-competitive in nature in the market. Otherwise, tie-in arrangements are always considered as per se illegal. And so, but at the same time we saw number of cases decided by the US courts, which clearly said that in the case of tying and bundling, if the firm lacks market power, and then the tying is not considered as anti-competitive in nature. So, it is the duty of the complainant to prove that tie-in arrangement or bundling arrangement which is abusive in nature and which is against the market. So, the purpose to be analyzed very closely in the case of tying arrangements as well. So, here I think the various reasons for tying which we discussed earlier, but the bottom line is that if the tying and bundling is abusive in nature, which is not going to increase the efficiency of the market or demand, it will be considered as anti-competitive in nature. If you look into the price fixing, the firm's price fixing also we discussed earlier. Price fixing is in various forms. We can find various type of price fixings. It is not only confined to the prices, only the price as such in technical terms. So, the price fixing includes the future prices, pricing policies, proportional aspects or promotional programs. So, bids, the cost, so capacity, then the terms or conditions of sale, especially the credit terms, and also sale back or credit back, discounts, then identity of customers, then allocation of customers in a geographical wise, production quotas, R&D plans. There are all these headings will come under price fixing. So, it is not just fixing the prices. So, all these the agencies to look very closely into what is the objective of price fixing, they have to very closely look into. Then comes the bid rigging. So, bid rigging and cartels we will discuss very elaborately, and bid rigging is considered to be pernicious to the market, because it is absolutely considered as illegal in nature, because if two or more people or two or more firms and they come together, they come together on a prior agreement and they are bidding. So, this will be there is no competition as such. So, because the competitors agree to take turns being the lowest bidder. So, they will sit out and in the bidding round, and they will be sitting for the next round of bidding. So, this is unacceptable, this is absolutely unacceptable to the market, because this is a bid rigging. Absolutely bid rigging agreements are in the form of subcontracting also is considered as bid rigging and cartelization, and even joint ventures, forming joint ventures for bid rigging is also will be considered as a violation of the antitrust provisions. So, the cartelization, the Federal Trade Commission to look into the cartelization, or Department of Justice has to look in very closely into the form of cartelization, into the form of bid rigging, the reasons or the joint ventures forming for what purposes, they have to look into very closely. So, and the most important thing is the geographical distribution of markets or customer allocation. So, we saw some of the cases very clearly, and the courts always said that these are violation per se illegal. So, these arrangements are it is the duty of the party to prove that this is not for curtailing the competition in the market, but mostly geographical allocations are considered as per se illegal under the Competition Act, under the anti-competitive provisions. This is considered to be anti-competitive in nature. So, market allocation, customer allocation, geographical allocation will be per se considered as illegal under the Sherman Act. And another form is the refusal to deal or boycotting. So, here refuse to do business with another firm. So, here you can see that one competitor cannot be compelled to do business with others, another competitor, but the purpose to be looked into. If the refusal to deal have a pro competitive effect in the market, then that is not illegal, but in most of the cases we can see that it is illegal. The boycotting or refusal to deal with a particular competitor will be considered as illegal. So, especially when there is a group of competitors are working together to capture the market or to capture with some of the objectives which we mentioned earlier, then it will be refusal to deal also will be considered as violating, and this also has to be looked into by the Department of Justice and the Federal Trade Commission. And if you look into some of the other arrangements, any other kind of arrangements which is going to affect the market will be considered by Department of Justice and FTC, they harmful to the consumers, harmful to the market, which is anti-competitive in effect or nature, will be considered by these law enforcement agencies, and but they will always apply the rule of reason. So, these agencies, two agencies work in tandem to look into all these kind of activities in the market, and to see that everything in the market is to achieve pro competitive benefits to the consumers. So, the law enforcement see that is very complicated as well as very co-activity of these two agencies in the United States. But when enforcing intellectual property related antitrust cases, these agencies found challenging or tensions between the antitrust enforcement and intellectual property protection. And these exclusionary contexts, all the contexts which we mentioned above, whether it is tie-in or it is geographical location, etc., etc. So, these violations coupled with intellectual property protection, the determination is very difficult and challenging to these particular agencies. And we discussed in this class specifically the enforcement agencies of the United States, that is the Department of Justice and Federal Trade Commission, what is their mandate, and also what actually these agencies looking into the different areas of enforcement. And these agencies are very important in the case of enforcing intellectual property related competition cases, because these are the two agencies engaged in day to day basis to deal with either corporations or individuals in intellectual property related competition cases. So, I would say that, and United States is the one country very liberal in nature in the case of doing business. At the same time, they are very strict in enforcing these antitrust laws, and especially in the case of antitrust involved intellectual property protection cases. The best example is the Microsoft case. Microsoft involved case, there is a series of cases where these tie-in arrangements and bundling was involved and other cases. So, whether it is the United States or in the European Union, the antitrust provisions are considered as very serious legislation. That is why you have enforcement agencies very strictly implementing these particular legislations. If you look into India, so we have to learn many more things from these particular agencies for the enforcement, as far as the enforcement is concerned, because we are in a very nascent stage of the enforcement of competition law. Our market is not a mature market, our market is still developing, and we opened our economy in 1991, and still the market is not mature enough to accommodate all the provisions of the competition law. But I would say that our examples on whether it is the cement industry or the airline industry or any other industries. So, we can see a lot of cartelization in the Indian market, and the enforcement with the Competition Commission. So, Competition Commission requires a lot of expertise to deal with these cases. Ordinary cases, especially when it comes to the enforcement of intellectual property related involved cases, they require a lot of expertise. For the case of again the Microsoft case, the Singania case in India, and the latest case in the case of Micromax case. So, you require a lot of expertise in the enforcement agencies, you require a lot of expertise in judiciary to deal with these competition involved cases. So, in the United States these two agencies play a very crucial role, and our competition commission have to look into the operation of these agencies in enforcing the antitrust competition law. So, I hope that this comparison will help us to learn many more things from other jurisdictions. Thank you.